It is a pleasure to see you again on my CryptoQ Media channel. It was Judge Analisa Torres who gave Ripple and XRP a fighting chance. The cryptocurrency market as a whole received a boost in July of last year when Analisa Torres, a federal court and friend of the cryptocurrency sector, handed Ripple a partial success in its battle against the U.S. Securities and Exchange Commission. The industry judge saw this victory as a huge step forward. Torres included this profile among the most significant, even though he ruled that Ripple had violated federal securities laws by selling XRP to institutional clients instead of common users through exchanges. The 2023 CoinDesk token issuers and trading platforms are unprotected, and the proper application of federal securities laws to digital assets remains unclear due to a lack of legislation in Congress. Because of this, the Bitcoin industry and the Securities and Exchange Commission can't settle their differences. The present laws, according to businesses, are inaccurate and antiquated. The American judicial system must determine whether the SEC's interpretation is right. Advertising at issue isn't just a student. Issuers of assets categorized as securities are subject to stringent transparency and registration requirements in the U.S. Crypto companies claim that digital asset issuers are unable to meet the requirements of these rules. Decentralized and disintermediated token trading platforms are subject to the same stringent regulations as their traditional financial counterparts. The very nature of the assets makes this possible. And if an asset isn't considered a security, these businesses have it made considerably easier. The District Court for the Southern District of New York is supervising 12 crypto lawsuits, including several claims lodged by the Securities and Exchange Commission, making this topic very significant there. In light of Judge Torres's ruling, Ripple may engage in unlawful sales of XRP to ordinary investors via exchange-blind bid hacks in the future. What the jury decides can end up being a benchmark that companies can refer back to time and time again. Those who bought XRP through programmatic channels have no idea which XRP vendor their money actually went to. In his decision, the judge noted that most XRP buyers from digital asset exchanges had no intention of investing in Ripple. There was a contractual contract in place when a major buyer bought XRP from Ripple. Programmatic buyers were statistically no different from secondary market buyers in that they had no idea who or what they were paying. Think about how the decision rocked the entire organization as one example. Nevertheless, concerns regarding the example it established emerged in its wake. A lawyer whose clients are involved in the Bitcoin sector and exchanges both benefited greatly from the decision. The ruling may have a good effect on Bitcoin projects and businesses, but that's just speculation. For the time being, the verdict will only be heard in one courtroom within one building. It is highly probable that the Securities and Exchange Commission will initiate an appeal after the matter concludes. It appears as though the goal is to expedite the appeals process. The regulatory body has already rejected the accusations leveled against Ripple executives Brad Garlin and Chris Larson. As mentioned before when speaking with reporters, if the Court of Appeals confirms the ruling, it might pave the way for initiatives to seek funding. According to Judge Jed Rakoff, who oversaw the SEC's case against Terraform Labs, Judge Torres's finding may stand out in his summary judgment order because he, too, disputed Judge Torres's reasoning. The particulars of that rule were clearly unique to that instance, just as the specifics of the Ripple ruling were unique to this case. As a result, the Court of Appeals may take some time to make a decision. The Securities and Exchange Commission will not be able to lodge an appeal unless the case is resolved. Because Judge Torres has scheduled more processes that will continue until April 2024. Ripple CEO Brad Garlin claims that the company's long-running legal battle with the SEC has taken an unexpected turn. His hints about an impending showdown ignited discussion about a possible resolution or significant turn of events. In response to this tweet, Bitcoin-focused attorneys moved quickly. "The buzz is for naught," says crypto law specialist Bill Morgan. He believes that the conclusion of the legal struggle is signaled by a settlement meeting. He takes his time to emphasize that a settlement is different from an epic confrontation. Giving something up is a must. The two parties will have opportunities to resolve their differences, obstacles to overcome, and areas of agreement. According to Morgan, settlement discussions are highly improbable. He makes a good point that settlements are the norm for conflict resolution, but there are a number of problems with this strategy, including the fact that appealing the judgment can be a major hassle and the fact that the settlement's actual consequences might have far-reaching consequences that aren't even contemplated yet. There is talk that some of the funds held by that infrastructure might impact XRP sales following 2020 and beyond. It means a lot to me that you've subscribed and watched my channel. We will meet again later.